Since we never filed an affirmative reply, I pray for speed of thought. Please like Your worship, the applicants made an application under Article 33 6C. Although my senior colleague was required to say Article 25. Your legal was saying Article 25, but it's Article 26. I can't give for the correction. Their argument is that the applicants,
the magistrate is not allowed to be shown.
6 months. And they are premising their argument on the charges under the General Court Martial.
Where the first two applicants, that is the kind of that is arrested and urge of that Lutale appeared.
On the 20th of November 2024. The defense or the applicants are also relating the same the charges that the applicants are facing before this honorable court. Article 23.6C, which is the basis of this application, is to the effect that where a person is arrested in respect of a criminal offense, and in the case of an offense triable, only by the High Court. If that person has been remanded in custody for 180 days before the case is committed to the High Court, that person shall be released on bail on such terms as the court considers reasonable. This article is perfect. However, it doesn't apply in the instant case. Why? The applicants appeared before the General Court Martial. On charges which are triable, not only by the High Court, but the lower court. That one collapses the application because the article is very clear. Only, let me repeat it. If that person has been remanded in custody, in the case of an offense triable, only by the High Court. The charges the applicants were facing before the General Court Martial were not offenses or charges that fall under Article 33(6). In other words, it is only the charges which the applicants are facing before this honorable court that apply under Article 23(6)(c). This is a total misinterpretation of the Constitution by the defense. The applicants appeared in this court, which I may refer to as the civil justice system, on the 21st of February 2025. And this legitimate charge, which this honorable court has jurisdiction over, on the 21st of February 2025. That said, even if the applicants were facing charges that are referred to under Article 23(6)(c) of the Constitution, the charges of the General Court Martial do not apply in this honorable court, because the court martial is under military justice system. And this court does not have powers on any matter that is before the General Court Martial. The same applies to DPP, the Director of Public Prosecution, whom I represent today. So it would be irregular to bundle the two justice systems and hold the civil justice system liable for, or responsible for what happened in or before the military justice system. As if that's not enough. The charges under the General Court Martial ceased and were terminated by the constitutional ruling of the Supreme Court. In other words, DPP never inherited any charges which were instituted before the General Court Martial. DPP initiated or directed for fresh and new investigations, which are the basis of the charges that the applicants are facing. The applicants furnished this court with a copy of the charge sheet, which was before the General Court Martial, and I believe this court takes judicial notice of the charges on the charge sheet apparently before court, and if that is the case, court may realize that the charges do not speak to each other. The General Court Martial has different charges, there are different charges, and here the applicants are facing charges which are completely different. But even if the applicants were charged with offences which attract death, even if the applicants were charged with offences which attract death before the General Court Martial, the civil justice system where this honorable court falls does not have jurisdiction and does not enforce the UPDF Act under which the applicants were charged. So that makes the two completely different. Your Worship, the question is, does this court have record of the General Court Martial? And if it is true that it does not have the way I believe, then this court, where does this court get the moral and legal authority to be bound by proceedings which are not before it? We invite this court agree with the prosecution that this court does not have any moral or legal authority to consider the record of proceeding in the General Court, even if it had it, because this court was not party to that. This court did not in any way inherit the proceedings of the General Court Martial. And I beg also to question, ask again, and I also ask this court, ask itself, when did the charges against the applicants, when were they filed before this court? When did this court first interact or come into contact with the applicants as a civil justice court? It It is simple mathematics. It is on the 21st of February 2025. And that translates. What does that mean? Lawyers are not good mathematicians. They do not count money. But I try to count. The applicants have been in custody for 3 months and 8 days. So that they have been, before, they have been on remand not more than 4 months. To put it that way, generally. Now, if that is the issue, if it is true, they have been on remand for not more than 6 months, are they entitled to the provisions under Article 23, Clause 6C? The answer, Your Worship, is the negative. No. And if that is the issue, the other question is, was this a misinterpretation of the provisions of that article by the defense? We invite this court to answer it in affirmative. Your Worship, we do appreciate the provisions of that article, and we would have no problem court releasing the applicants if they had blocked the mandatory period. But they have not. This court would have assumed the jurisdiction which is over and above that it has in a simple justice system. My brothers quoted several authorities in that regard. They quoted so many cases. It is a submission that prosecution agrees with the defense that this court is by law supposed to protect all the rights of the applicants before it. But court should not also have this matter handled automatically as it was submitted by my colleagues under Article 126 of the Constitution. Even if the applicants, for example, if I'm to play a devil's advocate role, even if the applicants had blocked mandatory, prosecution duly noticed, put the defense, the applicants on notice that they are ready to commit the applicants. Be on notice. That mere notice ties up the hands of this court. It is our submission. That ties up. And any decision which is on the contrary would be administering substantial justice on a matter of technicality. How? Because the defense submitted that Article 23, clause 6C applies instantly, and that court cannot do anything else for as long as they have this person all up blocks mandatory period. Our argument is that even if they had blocked mandatory period, the mere fact that we put them on notice that our committee papers are ready, the provisions under Article 23, Clause 6C is not a ticket to have the applicants released on mandatory bail when the committee papers are available. Because the issue then is, what is the substantive justice here? The substantive justice here is to have an expeditious trial of the applicants, which can only be done after being committed to high court. The argument by defense that, the first thing we have to do is to consider mandatory bail, let the applicants be released on mandatory bail, then the rest come later. That is thinking selfishly. It is acting contrary to Article 126.6.2e, which they quoted. They took a lot of time. The program just about 10% of the time. So it is a submission, Your Worship, that this court disregards and dismisses the application by defense on the basis that this court has no control over matters before general court martial. They have not locked mandatory period of time. The fact that they were remanded on the 21st of February 2025. Because this application, Your Worship, is in bad faith. It is in bad faith, especially given that the committee papers are available. We are ready to commit. We have been on record several times, and we have submitted that defense has been arm-twisting prosecution to delay the prosecution of this matter by using all the tricks available, all tricks that are actually at their disposal to ensure that they frustrate the process. They should have been the people who should be agitating for an expeditious trial. But now they are speaking the other language. Because as prosecution, we believe that now that our committee papers are ready, it doesn't make sense to have the applicants released on the mandatory. It is our prayer that these persons or the applicants be committed and have the matter expeditiously tried, because we are ready. We invite this court to dismiss the application. They are tainted with that in this application. So,
one of the things is, when does the period of remand come to? And I'll start by giving the court an authority which was determined in April this year by Justice Isaac Wanta. This is application number 133 of 2025, arising from criminal number UPDF GCM 022 of 2020. Besigye applicant versus Uganda. And in this case, I will not go to the details, but I'll come to the end of it, where the court says, I find that the applicant has satisfied the requirements for mandatory bail under Article 23(6)(c) of the Constitution, Section 15(2) of the Trial on Indictments, his detention of over 1,500 days without trial, and committal qualifies him to be released on mandatory bail. This person, the 1,500 days being referred to, is the remand in the general court, in the court So this authority sorts out the matter of whether the period of remand in the court martial counts. Number two, it would be absurd to construe the period of remand as 3 months. And I'm urging this court to take judicial notice because these matters have been very public. Since the judgment of the Supreme Court on the 31st of January this year, the A1, A2 have been in court applying for bail, and the prosecution has refused to concede to bail. They were not released by the authorities even after the judgment. How then can the court take the period of remand under the General Court Martial before we came before this court? Under what warrants were they being held? Was it state to the order of the state, which continues to oppose bail application? My friend cannot appropriate and reprobate. He must decide what his submissions are, but not one time to oppose bail and say they are lawfully held, and then to come and disown the period for which they were detained as an extension of the proceedings in the General Court Martial. In fact, doing so is admitting malice, because if there was no connection, then the Attorney General would have been the first to say, release them, we are now doing new investigations. The Attorney General did not do that. So the submissions of my colleague, the prosecutor, is actually borders on admitting malice on part of the Attorney General. The court should not be caught in this conspiracy to deny the accused persons their liberty. I don't want to go back to Article 23 because it's very clear. It doesn't say the High Court only. It says, see, she says, in the case of an offense which is tried by the High Court as well as by the subordinate court, these committal proceedings are part of the trial. So the subordinate court initiates, and the High Court continues with the trial after committal. If that person has been remanded in custody for a period of 60 days, so if it was this court, it would have come for bail earlier. But because it's both, if you look at C, it's both the subordinate court and the High Court, they've been in custody for over 180 days. And it's very clear that if before the case is committed, and exactly that is where we are. We are applying for bail before the case is committed. Are we entitled to do that? Yes. And that's where we refer you to the Magistrates Court, Section 76. We are not doing it just because we dreamt of it. It's the law. It's written in black and white. That in respect, this is 76B. 76B. A. In respect of any offense punishable by death, if for a continuous period exceeding 180 days, which is where we are, if you allow me not to read B, to go straight, the magistrate before whom the accused person first appears after the expiration of the relevant period shall release him or her on bail, shall, on their own cognizance, notwithstanding that he or she is accused of the offense. So before any other act, before any other application, including the committal, and we were not aware of the committal, we came for our bail application today, and we are becoming aware. So if the court were to look at who has been delaying, we were at the court martial for several months. They never commenced the trial. We've been before the civil courts for the whole of February, March, the whole of April, and this is the end of May, 4 months. Who has held the prosecution from concluding? He cannot come and infer improper motive on us. Nona, there is very little room left for you to play. There is no discretion in this matter.
My colleague has something to join this career, so that we are organized and I'm coming back.
For to clarify on the authority that was shared, that has been submitted on my senior counsel, Martha Karua, under which the High Court released the person this day on 17th of April 2025 on bail. The person who had been remanded by the court martial, as it then was, for 1,500 days, that is 4 years. The court was presented with the same argument as has been presented here, that days of the court martial should not count. And my Lord, Your Worship, the court in debunking that argument used section 17 as then was. Your Worship, that section is the equivalent of section 9 of the Magistrates Courts Act, under which this court is set up. And Your Worship, for clarity, I will read verbatim. Right, Your Worship. Right, Your Worship. It says, the jurisdiction of the magistrate's court shall, subject to this act, and any other law limiting or otherwise relating to the jurisdiction of that court or the presiding magistrate, be exercised in conformity with the law with which the High Court is required to conform in exercising its jurisdiction by the Judicature Act. Your Worship, section 17(2) provides for the inherent powers of the High Court. And this section is telling you that you have the same power. Your Worship, in applying that section, the judge here said, Your Worship, again I will read right at page 5. Your Worship, of course, of time and rush. That is paragraph 4. The court said, where a civilian was initially charged in the former court martial, any subsequent bail application falls within the jurisdiction of the ordinary courts, and an accused is at liberty to exercise that right to apply for bail. So what if I don't know what counsel was serving me with this authority? So what if meaning this application is properly before you? Where else do you want us to apply? In the court martial? And your Worship, at the conclusion as was read by my learned senior, Your Worship, it is paragraph 4 of that judgment on page 5, the ruling. After that finding, the court went on to find that all the 1,500 days spent on remand on account of the court martial were actually days that were counted. And the court counted them and released the person. So Your Worship, being the position now of the law being, you cannot say that proceedings of the court martial are not counted. In any case, Your Worship, this is what, if you rule like that, this is what you're going to see. That the people who are serving time now in the prison because of the court martial are actually free. We would be glad to take that finding. But that is the extent of what you're saying. That whatever they are serving is not counted. So let them be released. In any case, Your Worship, as my colleague was asking me, where did the state pick the accused persons to bring them here? Did they pick them from their homes? Did they pick them from their workplaces? They picked them from Luzira government prison. They are serving time on account of the document. So worship again as we close, so that I see the front of my learning. That time is as good as time that they have spent when they came. So worship as I close, that is the submission of the court. I see the court should take directly as submission.
Worship, the issue of the 80 days has been tackled extensively by my colleagues. 180 days. I just wish to reiterate that Land Council for the State, Mr. Billy Mumbuka, conceded when he said that he would have no problem with them being released if the 180 days are met. In his view, the 180 days should start when the accused person were brought before this court. Your Worship, my colleagues have cited authority to show that indeed the courts of law have found that the remand period where there has been a court-martial intervention start from the time of remand by the court-martial. On that basis and on his own concession, the accused persons should be entitled. We take it that his submission and his concession was based on circumstances where he was not alive to that decision, but it clears him lest he's taken allowed to have the release. He said, I have no problem if they have clocked the mandatory period, but they have not, because he said it's a magistrate's court, but that decision has been cured by the higher court. The second one, my learned friend, Mr. Billy Mumbuka, alleged that the DPP brought new charges. He did so in an attempt to nullify the custodial condition in which the accused persons are placed. Your Worship, under the Evidence Act, we are alive to the fact that the court takes judicial notice of documents of the court record. Your Worship, in the criminal application number 1 of 2025, I'm referring to, my colleague is unhappy, but I'm referring to that notice of motion which, Your Worship, was endorsed by the Chief Magistrate. So it was owned by the court. It is a court record.
But did I submit to this?
I request that he listens to me. And if I may just, Your Worship, put the matter in proper perspective, the application was brought at the instance of the land chief state attorney, and he was pursuing this application with vigor. So he's alive with this application. It was an application to access, and he brought it up. Your Worship, that notice of motion, as it should be, is supported by an affidavit of BIP, or the benefit. I would want to refer to the first 4 paragraphs.
But Your Worship, I think this is the way. I know what has been approval with prosecution. I know that, Your Worship. But again, as prosecution, we cannot see when there's something wrong or wrong. First of all, we never responded anything in this of that prosecution in our response. I believe that my senior colleagues will be making a rejoinder on specific issues which we raised in our response. Yes, that was not part of it. Secondly, his raising other issues is now going into details of the evidence, which was never part of our response. Your Worship, I respect my senior colleague. You understand? I do respect that, but being senior is not a prerequisite to go into details which were never brought up at any point during the trial. I pray that this court prevails over him to speak and submit and address of other matters which arose in the reply.
Your Worship, if I may, I am responding to the contention of the DPP having brought new charges.
Okay, so restrict yourself.
Absolutely.
Don't make it.
Yes. And I'm mindful of the fact that again, the affidavit my colleague is objecting to wantonly was drawn by the DPP. It states as follows, my Lord, Your Worship. In paragraph 2, yes, I'm just referring to my Lord, it says that the respondents are accused persons in a criminal court number 8 of 2025, which is the matter of the The respondents were previously charged before the General Court Martial at Besigye and were being tried there. However, following the chair of the Supreme Court in Constitutional Appeal number 2 of 2021, Attorney General versus Michael Karasuluka, the case was transferred to the Uganda police. The Uganda police took over investigations of the case on 11th Feb, and I was one of the officers who was assigned to investigate the case. The case was transferred. It is in the affidavit. Your Worship, when you transfer, let's be practical. Your Worship, if you transferred your car to me, I inherit it.
God forbid.
So, there are no fresh charges. As a matter of fact, and my learned friend referred to the Supreme Court decision. The Supreme Court decision actually directed that the files be transferred. It did not direct that those charges be dropped and fresh charges brought. So it is coming as a transfer. It means that the process is continuous. He cannot allege that these are new charges. A transfer, incidentally, and I read from my colleague notes, is a simple English word, not a legal one. The matter acquires a new conductor. We have the conductor in the General Court Martial. Now we have the conductor, fortunately and unfortunately, who is Mr. Billy. It was a transfer. The other one, indeed. Your Worship, in trying to disparage that article, he said it's not applicable because of the charges. One of the charges against the accused persons in the General Court Martial was the offense of treachery, which under Section 129 of the UPDF Act, the penalty is death. Applying it, I don't know the Latin one where I should be mutantis mutandis, but transferring it means that it is an offense because of the penalty, which cannot be tried by a magistrate court. It can only be tried by the High Court. And what it should be remembered that before the decision of the Supreme Court, the General Court Martial insisted that it was equivalent to the High Court, i.e., it was the High Court of military law. Only that now it was charging civilians. It is therefore a lame argument for my colleague to contend that because it says High Court only, and referring to that Section 9, this court is bound not to be mechanical in approach. If an offense in any other court has a penalty of death, it means that if it is transferred to the civilian dispensation, it can only go to the High Court. It therefore becomes an offense which can only be tried by the High Court in its original jurisdiction. As I wind up, Your Worship, my Lord, Your Worship, Mr. Bilibungu have tried to convince you not to refer to what we have said because the record of the GCM was not here. But in his opening remarks, he said that the accused persons were arrested in November and arraigned in the GCM. He did not furnish a copy of the record to support his allegation. So I don't know whether his submission is gathered from the sky or whether it should only be taken when he's submitted. It is not denied, and my worship, it is in the affidavit which he responded to. In paragraph 3, the affidavit of Kotobia Kubihira, which hasn't challenged, that in fact they were taken captive on the 16th of October and produced in paragraph 4 in the GCM on the 20th of November. Applying the decision of Mr. Justice Mwata, the period of remand then starts to run from the 20th of November 2024. Your Worship, again, my colleague referred to Article 26.3 not being applicable on the premise that the committal papers were ready. The plain reading of Article 23.6 says before committal. It doesn't say before availability of committal papers. So again, my colleague Mr. Billy Bumbuka knowingly is trying to read into the Constitution things, not even matter, they are not things which don't exist. The clause is very specific, and incidentally, the release of the accused persons on mandatory bail does not stop the committal, because they can be committed while they are on mandatory bail. So there will be nothing to stop this court from releasing them on mandatory bail, as they are now entitled to, and then they return to court with directions for committal. And the worship, that can be one of the conditions. We release you today, return tomorrow for committal. It is within your power. It is not within the wishes of Mr. Billy or the state. Your worship, I conclude, because sister and brother magistrates have declined to grant this order. They have shied away on the basis of matters being of the capital nature. Others have shied away on the basis of fear of what will happen if accused persons rightly entitled to mandatory bail are released. Your worship, decisions of this nature in these times can be challenged, but that is why we are in a court of law. It is the reason why disputes, however outrageous, however grave, however serious, are brought to the court of law, which is independent and which is free from influence and free from fear. Your worship, we cite in the Journal of the Discipline of Law by Lord Denny. Your worship, it states this, I'll just read it. Just to comfort the court that despite the circumstances, it is bound to exercise its duty. That if the powerful still abuse their powers without restraint, it is thanks to the dominant influence of timorous souls, timorous souls, my your worship, speaking to judicial officers or courts who shy away, exercise the power granted by them granted to them by the Constitution because of fear. Bold spirits will not let such abuse stand. Any rule of law which impairs the doing of justice, they will do all they can legitimately do to avoid that rule. They will even change it so that justice before them is done. We therefore appeal to this court. The Constitution commands the court to release the accused persons on mandatory bail because they have met the standard, subject to the conditions which the court provides. That circumstances are dire and perhaps strange things will happen, that is an after event. The role of the state, as I conclude, Your Worship, was very simple. Under section 76, the duty of the state, Mr. Bill, my brother, was to demonstrate with it. They are entitled to be released unless, before the expiration of that period, they have been committed. In this case, there is no committal and he has conceded. He has his papers ready, perhaps in his court, but has not done the commitment. Two, the magistrate is satisfied that it is expedient for the prosecution of the public that the accused person should not be released from custody. We have not demonstrated anywhere that these are a danger to the public. He has not therefore discharged his burden in any way, despite the time quote unquote. In any event, your brother magistrate allowed the public to interact with the accused persons and they were not endangered. To the extent that Mr. Bibum has not done anything to dispel or to prove his guilty, it is our prayer that the inevitable must happen, that the accused persons are released on mandatory bail, subject to the conditions which the court has fixed. Your Worship, in vain your indulgence, and I call the family that there's something they haven't covered, just to accord him 1 or 2 minutes to cover it. He says he has been piercing me to say there's something I've missed. I apologize.
Just 1 minute.
Much obliged, Your Worship. Your Worship, all matters have been canvassed. I just want to add in reply to Mr. Billy Mumuka's contention that states are ready to commit and therefore it should be reasonable as to why the court should not admit the applicants on bail.
I think it should be very clear, otherwise you have nothing to say. My argument was clear.
So let him submit and then
Your Worship, the authority I would want to cite to this honorable court is the High Court authority. Yes, Your Worship, because it's instructive. It's instructive on the issue of Your Worship, if I may, it's instructive. The authority is instructive, and I came here on the submitted authority report. It's instructive on the issue of the prosecution being ready to commit amidst a bail application, a mandatory bail application. And this authority by Justice Collins Ashley at the High Court of Bull, where the persons who were charged with aggregated robbery, stated that even if, because prosecution was requesting that it commits before the mandatory bail application is had, the learned justice had an occasion to say that even if the prosecution had papers in court, as they had then, you cannot overlook the provisions of the Constitution for entertaining and granting an application for mandatory bail, and therefore it can be done later.
Subscribe to the channel.
for its of binding nature to this honorable court, for it is a high court authority, and the authority is Andrea Charles and others versus Uganda, miscellaneous criminal application number 3 of 2024 at the High Court sitting in Arua. Your Worship, we shall provide the authority. My friend has stepped out to bring the same. And court admitted the applicants on bail, even when prosecution had papers in court saying that it was ready to commit the applicants. Much obliged.
Your Worship, we shall use less than 2 minutes. And in these 2 minutes, granted latitude, we shall instead characterize the submissions of which agreements and those that suffer from lack of focus and clarity. And also outrightly, we associate the submissions of Islamic Council, Martha Karua, and Frederick Chupanga, and the other councils in society.
With the leave of court. If the court is the
We are going for a court ruling about the bail application. We are going for a court ruling about the bail application. Share the live, share the live. Subscribe, like, and comment. The judge is going to give a ruling. The judge is going to give a ruling. The judge is going to give a ruling. Subscribe, like, and comment. This is the Heavy Media. This is the Heavy Media. This is the Heavy Media. Subscribe, like, and comment. The court, the judge is going to give a ruling about the judge is going to give a ruling on a bail application of today. So the judge is going to give a ruling. The judge is going to give a ruling right now, a few minutes from now. The judge is going to give a ruling. The judge is going to give a ruling. Omuyita n'azanyira mu kamera yange todda mumuyita aleeta feesi
naawe bwetubali ng'oteekayo kifeesi kyo
nze kiri si kifeesi nze kale nina kifeesi nange ekimanyi
katono oli ateekayo kafeesi ke nkuba
agala banteeke Besigye waali. The judge is coming with ruling. The judge is coming with a ruling. This is how the court is. It is right now. This is how the court is right now. The judge is going to give a ruling on the application of Dr. Kingsley Besigye a few minutes from now. The judge is not supposed to be shown Those are the rules of this court. You want me to join Dr. Kizza Besigye, my brother? The judge is not supposed to be shown. If you want to see the judge, you come at Nakawa court, you're going to see her. Otherwise, the judge is not allowed to be shown in the cameras. The judge is not allowed to be shown in the cameras. If you want to see the judge, come to Nakawa. Okay, let's make 400. Ngezeko Baraka judge. Let's make 500. Share the live, we make 500 viewers. Baraka judge, Kali. Share the live. Ngina mnyamateka Justin aita chikizo. Abagala mnyamateka mbalaba bambuza, where is the judge? Where is the judge? Where is the judge? Bagambe bawele bitano umenya amateeka naye bagambe sobola okukanga mwendakiika emu bati bali kulayo. Ne bwoba ompa ssente jjaji sisobola mukulaga muganda wange. Ne bwoba ompa akakadde sirina jjaji jangu Nakawa omulabe. Abagala olaba jjaji ntegedde temunjagala. Wallahi. Yogera ku mukama wange. Jabasobola mmwe. The judge is not supposed to be shown.
Kitumalako emirembe.
Nga kisala ebifaananyi. Kyana ekyo. Kati kiba kikijja leero.
Kasita mukama.
Labayo meseji yammwe. Abasirikale bali kulayo. Babadde babawulira. According to the defense lawyer. Interview. The doctor. Nawe. Omusajja nkwata mutwe gwe. Omusajja ekifaananyi yange kyeyalikoze. Singa ndi wano bwenti kati. Naye waliwo omutwe gwe okulaba. Breaking news. Breaking news. Akanaka wakati. Balo yawa. Uganda is Anytime from now, we are getting the ruling of the judge. Yes, anytime from now, we are getting the ruling of the judge. Subscribe. If you have I don't need NBS, my brother. Singa jendi nawe bampa omulimu nga bampa $5,000,000 sikola ku NBS. Amagwa gwe Ronald wamagwa otegeera kubanga toyinza kuŋŋamba mbu nkulaga ejjaaji kugambye the judge is not supposed to be shown. Ye jjaaji oyagala waaki oyagala mukwana omwagaza ki jangu enakawa. Come to Nakawa, my brothers. Wow, who's that? Oje. You've ever seen something? Anaki. It is the Heavy Media. Subscribe, like, and comment. We are waiting for the ruling of the bail application right here in the court of the Magistrate Court of Nakawa, and we are live at Nakawa. Abafe. The number is on the DP. Again, I'm on DPR channel. Over Secho, but we got the number 0787. Yeah, 0787 103 103 136. For those of you who want the number, 0787 103 136.
Made by the defense for the release of accused persons on mandatory bail as provided for under Article 23(6) of the Constitution on the basis that accused persons have clocked the 180 days spent on remand before committing. The defense has made detailed submissions that Article 23(6) is a command of the Constitution and that this court does not have the discretion but rather sets the terms for the bail. The prosecution in reply submitted the charges that were under court-martial seized and were terminated by the constitutional decision of the Supreme Court. The prosecution submitted that the accused have spent 3 months on remand and not 180 days. The defense in the letter submitted that the proceedings in this court are a continuation of the proceedings defense has provided a number of authorities to buttress submissions for grant of mandatory bail under Article 26 of the Constitution. This court is mindful of the provisions of the Constitution, Article 23(6). However, this court also takes cognizance of the Constitution bail guidelines, Court of Judicature 2022, which commenced on 28th June 2022. The charges that accused the charged with a capital in nature. Practice Direction number 10(3) of the guidelines provides that to avoidance of doubt, mandatory release on bail for offences triable by the High Court of the Constitution under Article 23(6) of the Constitution shall be granted only by the High Court. This provision outs the jurisdiction of this court to grant the applicants mandatory bail. The fact that this court's jurisdiction is ousted by the Practice Direction number 10(3), this court cannot go ahead to determine whether the days on remand cover the period before the accused remain before this court. I wish to also add that all the authorities cited by the defense are authorities of the High Court, which granted mandatory bail in capital offences, which is well within its jurisdiction as per the bail guidelines. For the above reasons, this court lacks the jurisdiction to grant the applicant's application for mandatory bail. The applicants can apply to the High Court for mandatory bail.
Your Worship,
cited by the 11 says that once you do that, then 11.3 says that you immediately transfer the file to the High Court. I pray that you abide that way. Yes, this is the guideline that what is using, so I would want to read it. The procedure for bail, that is the heading. Magistrates Court shall submit the High Court files of persons eligible for mandatory bail. Subsection 2, an application for mandatory bail in the High Court. So basically that is subsection 3 of section sub-headline 3 of guideline 11. It says that this court submits for mandatory bail.
Your Worship, joining the issue. Again, citing those guidelines. Because those guidelines, just to put it, create a link, provide that an application for mandatory bail in a court of this nature will be oral. We have made no application. The court has found, as it did, that it does not have this. It has not found that the accused persons do not qualify, meaning that the matter now, the issue, is about. Therefore, I'm relying on the same regulation or guideline. 3 reads, the magistrate court shall submit to the High Court files of persons eligible for mandatory bail, and upon receipt, the registrar shall cause the files be registered in the bail register. To that extent, and guided by the first sub-regulation, which provides that applications in the magistrate are oral, ours is an oral application now, given the filing of court, for the file to be forwarded to the High Court, which is a command to the registrar to enter it in the bail register so that that application is. It appears to be mandatory and not discretionary, so we reckon that once it's been referred to the court, it is bound to abide. I reckon that the response from Mr. Bilbika will be to affirm the mandatory command so that going forward, the file proceeds.
Much obliged, Your Worship. Then it should be on record.
That is a critique. That is a critique of the ruling which you are not prepared to do.
It is
You
fine.
have
Let's
it on record now. What's the purpose?
just submit.
Your Worship, we pray that court makes him on record, because we are now starting to
Make the submission.
Your Worship, it is on record that we filed a bail application in the High Court. Your Worship, the bail guidelines under specifically guideline number 8 provide for time to dispose of the bail application. Your Worship, it's now 1.5 months, which is over 30 days. Yet in the bail guidelines, they clearly state that a bail application shall be disposed of within 30 days upon its filing. Your Worship, up to now, our bail application we filed has not been fixed or even heard. Now, what we want to be on record is that in this ruling, or in this trial, in this case, there has been selective application of the guidelines that we are using in bail. Because if this court is applying them to say that we must go to the High Court, but the High Court where we are is not fixing our application within 30 days as mandated by the guidelines. We submit that that is a clear selective application of the guidelines. And my Daniel brother now can come in emphatically to say what he wants to speak.
Your Worship, President Chiza and Council we go to 10.2. I shall read. In the case of a person who has been on remand for 180 days in accordance with Article 236C of the Constitution, the magistrate court shall immediately refer the file to the High Court. Your Worship, let's have a prayer that the file be referred to the High Court.
Again, this is the report of interpretation. that environment colleagues are relying on. One, for a magistrate to refer a matter to High Court in case of mandatory bail, that court must have pronounced itself on the fact that the applicant or the accused person has clocked mandatory bail in custody, which is not the case in this regard. It is not a duty of this court to pave way for the release of the applicants. The applicant has a fleet of senior lawyers who can move High Court in this regard. There is no basis for this court to refer this matter to the High Court because the applicants have not clocked mandatory period in custody. You cannot have a matter in February and then in May you say the applicant has clocked mandatory. It is simple mathematics. This court has no jurisdiction. In other words, that application is misplaced. If the applicants wish to make an application before High Court, they can do it on their own initiative, not through the vehicle of court. That court should move them. And it's not, by the way, it's not the fault of you, Your Worship, that the application which my brother Bayan has been submitting upon has not been fixed. And therefore, I don't want to use a harsh word. I want to use it. But it will be, that's what you have been giving them a lot of time. But when it comes to me, you give me one thing. What are we This request is misplaced. They know where to go in case they want the application to be fixed. In summary, Your Worship, I pray that you dismiss that application and we proceed. We proceed with the amendment of the charge sheet and other processes for today, as prosecutors have actually addressed both.
A very brief rejoinder. We have cited the guidelines. We cited the requirement of the court to submit the file. Unlike my colleague, Mr. Philip Mbuka, court did not say that the 180 days period has not been met. But Your Worship, catching from 3, where a magistrate shall submit to the High Court file of persons eligible for mandatory bail, and upon receipt of the evidence shall cause the files to be registered in the bail register. 4 says the register shall list the files submitted under paragraph 3 for hearing by the judge. 5, which is very important, says upon disposal of the bail application, whereby it may be granted or it may not be, the file shall then be returned to the magistrate's court to enable the court to proceed with the commitment. It means that once you applied for bail and the court has found as has as a matter of the High Court, once you have applied, in fact, Regulation 3 doesn't require that you apply, it requires that the court forwards the file. It means that because it is a right of the accused, all other proceedings stop until the matter of mandatory bail is handled. So again, the words in that regulation do not say may. It is shall. As lawyers and advocates who appear at the bar, we are enjoined to be official court. We are praying, Your Worship, that you do not allow Mr. Billy to mislead the court. So, we are therefore saying that the command is that they file before. We also refer to the same regulations, which is Rule Regulation 10, Sub-Rule 2. Person who has been on remand, which my colleague referred to, more than only days, the magistrate shall immediately refer the file. Mr. Pilmuka will have his day in court to make all the healthy submissions. We are saying that this court, this ruling, now does not have any matter to deal with this one. Let us go. We shall return when that matter. And perhaps we are certain that when we go away for a bit, it will allow this court some respite. So we pray that we go to the High Court to determine that right which cannot be abrogated. Then we shall come back when the court has pronounced itself.
One point. We appreciate your ruling, although we were of a different mind. But now that the court has decided to adhere to the guidelines, we are asking the court to be consistent and therefore in line with guideline number 10.2, as urged by my colleague, to immediately refer the file. It would be quite untidy if the court was to adhere to the guideline and then not adhere to the guideline. So for the sake of consistency, predictability, and the appearance of justice being done equally across the board, let this file go to the High Court.
Yes, matter you I see. The question is very important. It is very important.
I have what I quoted. Let me make my
Order, please.
wabula kyewankoze
amanyi olumbe tusula mu nsiisira nga tugenze mu lumbe olumba tugirekawo
abantu baba bazze kubalaba
olutalo bali wabba abantu
omulaba leero kyokoze ekyo ng'oyimiridde wano nange eva bwebwabira wano kyabadde nga nkola naye leero am happy that yakifeesinze
naye kuba ne kadi 6 wano
kadi ki
kansirikire bangeme ebifaananyi
vidiyo zembeera nkwata ziba zirina ku twitter
antubira ne kadi nga 6
anti
vidiyo ziba zigenda
kutagiwa kamera amenya ku twitter
ate gamba onamuteekerayo ku twitter ng'otose ku ssaawa 8 nga koti yatandise ssaawa 6
omwana musala resolution
olabye wekifiiringa oddanga
ayinza obadde era mugamba simukuba ngolo
balabye ku nkoona yange abantu
obedde abagira
gwe nonkola naye ono
amina
ng'akabaringa essimu yonna
balina okimanya gye tujja footage omuwazibu
gulaba omutwe gwange gunkana n'ogugumu
okimanyi nti tracking shot bwe bateri mu kukankana tenyuma okota shot ya tear gas we batekangana tenyuma
Tracking shot. Sawa ya kugaba ruling ku nsonga zino zibadde basubmitinga bail application yo erabika nga yagaaniddwa era ba defense councils basaba bail application egende oba okusaba kwa bail application kugende mu kooti enkulu mu Kampala. So tukyali wano Nakawa, wano ku Nakawa Magistrate Court mu maaso g'omulamuzi tuchagendera ddala mu maaso. Just in case you are following up, subscribe, like and comment. Oyo gwolaba ye Dr. Kizza Besigye. Ensonga zonna ate tukyatambulira ddala, ogenda banga ofuna ddala buli kimu okuva gye twatandikidde abakyalinaffe. Thank you very much. Oli ku Heaven Media.
The court has made its decision on the application for mandatory bail. Court having ruled that it cannot grant the application for mandatory bail, the defense has submitted that this court should, as per the guidelines, submit a file to High Court for the application for mandatory bail. This court has not pronounced itself on whether the accused persons have clocked the period of mandatory bail. And as such, this court cannot cause the file to be forwarded to High Court as provided for under guideline number 11. Considering that prosecution intends to amend the charges and make other proceedings thereto, prosecution should proceed with the application for amendments to the charge sheet.
Before my colleagues, our instructions are to seek a revision of that order.
It is well. The revision will be made, but for now, it was.
I know that when we ask for a revision, because the decision will continue after our revision has been rejected, it will not be a subject of the revision. It is not proper for the court to continue the trial. Our position is strengthened by the Supreme Court decision of Charles Onyana and Mwenda versus J. Mulenga J. SC. Yes. The import of this decision is that when a process in the lower court is under challenge in the higher court, the lower court must wait lest it proceeds and this decision or procedure is found to be faulty in the critics. So our request, because we have sought a revision under the Criminal Procedure Code, we are referring to 848. We are asking this court, asking the court to review the file, including the decision regarding bail, mandatory bail. Yes. But we are going to apply for a revision. We are applying for a revision. So we shall be requesting the court, the higher court, to review the proceedings in this court. To satisfy itself as to the correctness, the legality, and propriety of its finding. So to the extent that we are testing court regarding the legality, the propriety, and the correctness of your finding, we beseech you to stop so that the file goes and checks the correctness of what we are doing. Your Worship, because we are told that we are submitting decisions of the High Court, the application, criminal application number 1 of 2025, the very one we are referring to Uganda versus Kano Besigye and others, that is what happened. When the court made a decision regarding the cross-examination of the deponent, whether it be in public or in a closed court, and we sought a review, the court stopped henceforth and deferred the file to the High Court. It is our same prayer. Circumstances are the same. We are praying that you allow, most humbly, your worship, to submit your proceedings to the higher court for correction. It is the request of the accused persons. They feel it is their right, and we should allow your worship to submit your proceedings to the high court, as indeed.
All right, let me just put on this. May I add one sentence to what Mr. Mpanga has said? Just to remind this court that this court has already made a decision, the brother judge, when there was challenge about access to the courts and the matter went to revision, the court halted that application pending the revision. For the sake of consistency, this court ought to agree to halt the proceedings until the revision is done. And I will repeat what I said in the beginning. Justice is about should be done, but also must seem manifestly to be done. And we should have equality of arms. It should not look like the court, the scale is dropping on the side of the prosecution. We want bail, which is mandatory. We are now asking that that matter be prosecuted fast, and not the prosecution's hurry for committal when there is mandatory provisions for bail. So kindly, let us go on revision, let us test the bail.
Lordship, for the record, Lordship, still referring to the same matter that of the criminal genius application which we submitted for revision. From section 48, we are supposed to go to the High Court asking for the file. So essentially, we can't ask the High Court while we are here, as it is now. Although our instructions are, we go to the High Court and ask. So what is essentially what we are asking for, and what your learned sister, our worship, Nyadoe did. She adjourned the matter, gave us, actually it was 30 days. We went to the High Court, asked the High Court, and the High Court called the file, and the revision is there. So actually, essentially what we are saying, that the court should adjourn this matter, allow us to move out, go to the High Court, ask the court to hold the proceedings so that we can go and handle the revision there. Otherwise, we can't ask the High Court to hold the file when we are sitting here.
You may wonder what we are interested in this proceeding, because there are two reasons, there are a number of reasons, but one of them is that under section 17 of the Education Act, this honorable court is subject to the supervision of the High Court. And under subsection 2 of section 17, paragraph C, the High Court has to ensure that the substantive justice is done, just like we are enjoined by Article 126 of the Constitution. That cannot happen, Your Honor, if you continue with the proceedings that the Constitution wants to bring to bear without giving High Court a chance to look at the record of today and entertain our technical and legal objection to the way that this court has, although it is obliged, calculated the remand period one of the two which have been taken place. So one of the questions for High Court is a magistrate empowered to decline to calculate remand days from 20th November last year to today? Is the magistrate legally in law, not in caprice, is a magistrate in law, not caprice, entitled to decline to calculate mathematically the days that an accused person or accused person now spent on remand? Our opinion is that is parliamentary and constitutional of that magistrate. We want the High Court to intervene, and it cannot intervene unless this court allows it. Because the point of mandatory bail, I would like to be on Your Honor, the point of mandatory bail is to ensure the personal liberty of the accused. It is not something made perfunctory. It is made so that life and meaning is given to the presumption of innocence, among other reasons. So this is a matter concerning fundamental human rights and freedoms of the accused person. So in making this application, pursuant to the provisions, my land calling Article 2 and Section 17 of the Educator Act and the other provisions, is that we are trying to go to High Court to cry out to the High Court and say that the person the bail guidance told to calculate days has refused and has said so in writing that I will have not counted the days. What is stopping her? The state will explain. Why is she refusing to count the days of the man? Yet the law does not even give her the option not to. Those are some of the questions that have been taken. Thank you very much. In reply to the application, the defense is seeking this court, one, to stop the proceedings before it. Two, refer the matter to High Court for revision. Because they want the High Court to find out whether the proceedings are in line with the procedure. The defense cited a matter which is before Uganda police. For whom they allegedly say stopped the proceedings and referred the matter to High Court for revision. What is the law on revision? That is what we begin from. Revision is provided under Section 48 of the Criminal Procedure Code Act. Cap 122. Those of Uganda. Revision is a preserve of the High Court. And the procedure is the defense make an application in the High Court. They make the application in the High Court. And then High Court, if deems it necessary or fit, calls for the record from the lower court. It is not anywhere in the law under section 48 and 50 of the Criminal Procedure Code Act that it is provided that the magistrate or the lower court who is in personal conduct of the matter under dispute is by law supposed to A, stop the proceedings, refer the matter, and send the record of proceedings to the High Court. It is not. The defense are using a completely different procedure altogether. It is the High Court instead which is supposed to call this record if it deems it necessary. And this court is, you don't have blood at any point to stop the proceedings in this matter because there is nothing wrong on the record. And by the way, there is no provision that defense has to lay out the reasons as to why they are seeking the revision. Whether you have 100 reasons, that is your own. You can only do that when you're seeking a constitutional reference, not in a revision. So the procedure they adopted is completely, that is irregular. It is misplaced
for want of a better one, for lack of a better one. The defense submitted that your colleague, when faced with such an application,
when we are before you. So essentially, it's an adjournment to make the regional application so that our client can exercise their rights. We do not want to proceed, and then the court says it's an application so that we advance so that may be the revision application, we prepare and file it. Otherwise, we cannot do it because of the same. We are going to seek that application because we don't need permission of the court. Thank you. And so we are requesting you that you court bears that in mind, because after all, we are going to review what has happened, based on legality, propriety, and succinct. We believe, like I said, that common sense will require that we stop here. The High Court guides us. We come back. We are not running away from here. We shall come back. We are saying we want it to be done in accordance. We don't want to proceed, yet we are reviewing, so that we have that's the simple. And I'm sure Mr. B knows, because even in that case, we argued a lot, but eventually so the it. So we asked him to see light earlier, so that we don't proceed. It normally takes long to see this thing.
No, I want to check. I'm trying to tell you. Your Honor, these are very serious matters. First of all, I think my brother misunderstood the scope of application. It's not just a revision application. This is also an application for supervision. And as I kept saying, but failed here, it is also premised on Section 17 of the Educator Act. You all logically, it will serve no purpose for us to proceed to the High Court if you proceed with today's proceedings by the prayers of the Constitution. In other words, you will be indirectly telling us that we don't go to High Court, because there will be no purpose of going to High Court if you are going to hear committal proceeding. It is both illogical but also illegally and unconscionable to entertain committal proceedings whose net effect is to frustrate the mandatory bail of accused person. In law, it is called abuse of the process of law. If a magistrate conducts court in such a way that when the prosecution senses that the mandatory bail application has been triggered or is looming, to ensure that there is a committal so that the accused persons do not successfully apply for mandatory bail, that is an abuse of the legal process. It is important that we be mindful of the context of this military proceeding. The accused here were not arrested in Uganda, were abducted, tortured, illegally detained in the military detention for 4 days before they were arraigned before a kangaroo military tribunal. Can I proceed? Please, maybe, what can guide us?
That's okay, sir. Don't raise the
Yes, I'm not raising issues. So Article 43 of the Constitution, and in the context that I have stated, forbids political persecution. What we are seeing here, the use of committal proceedings to stop mandatory bail is a stellar example of political persecution,
which is prohibited in absolute terms by Article 43 of the 1995 Constitution. A prosecutor is precluded from using his office to initiate committal proceedings so as to forestall mandatory bail. This is my opinion. I think you are not going to zip my mouth.
Just a minute, Your Worship.
That's okay, sir.
You see, Council, I don't want to take it up because it's what we call, we need to proceed in a manner that actually represents what we hold out. If you hold up as a lawyer, then present your facts and evidence as a lawyer. You cannot submit in this court and attack the office of the DPP that they are coming up. Yes. And you say that the office of the DPP prepared committal papers in a bid to deny the applicant from benefiting from mandatory bail. Do you have an argument with you? We are performing our role as DPP. So there are some things, yes, there are some things that shouldn't be said here. Otherwise they become too unprofessional and courteous.
Yes, I'm finishing. Subsection 5, clause 5 of Article 120 on the powers on the Office of the Director of Public Prosecution reads as follows: that in exercising his or her powers under this article, the Director of Public Prosecution shall have regard to public interest of the administration of justice, and the need to prevent the abuse of the legal process. What are we seeing here, Your Worship? A classic example of the abuse of the legal process by the Office of the Director of Public Prosecution, in his words, claiming that they have come with the committal papers so as, in my opinion, and the opinion shared by the entire legal team and the accused persons here, to frustrate mandatory bail. We implore this honorable court to prevent that abuse of legal process, because it is also tantamount to political persecution prohibited in absolute terms by Article 43 of the Constitution. We cannot run away from the context of this matter. Thank you.
What is true, just for a few minutes, then I come back
Genda kukola interview tuvewo. Omulamuzi Kisa Kitabuse agambye agenda kudda.
Thank you so much. I think I'm not going to matter no more. All right. Koti ewumuddemu ekiseera ekitali kigere. Koti ewumuddemu ekiseera ekitali kigere naye
Ngenda laba oba tweyongerayo n'eno oba tukoma wano. Nalakola just don't talk about.
Kanza biribu. Kanza biribu.
Aaron Keys agenda mufuna agenda tubuulira buli kimu. Abakyaliko subscribe, like and you better like and comment tubeerenga tukwasaganya ensonga zino. Share the live, share the link. Batugambye tukomawo okusembayo naye sisuubira nti